Andrew. Okay, and we are recording this meeting for anyone who would like to reference it later on. Andrew, thank you so much for coming. Andrew is a trust attorney and he is sharing his time with us today to go over, any type of common misconceptions. Are there any attached liens? What are the different tax benefits of trusts? How do we avoid probate, blah, blah, blah. He's the expert, so I'm going to let him talk. Kyle and Andrew, take it away. Thank you so much.
Yeah, great. Andrew, do you just want to introduce yourself a little bit, give us some background before
Yeah,
we get
I
started?
can do that. I can do that real quick, and then just a heads up. As a lot of us, I'm working at home. I've got two dogs here, and they're great. But if there's a delivery, you will hear them. So
We're all in this together. Don't you
just a
worry.
heads up. So I'm Andrew Cohen. I am a trust and estate attorney. I'm from the East Coast. I grew up in outside of Philadelphia. I've been in California for since 1998. I'm married. My wife teaches Pico Elementary School. We've got three kids. Our oldest is graduating Hart next week. Our other son's also a soccer player. He's at Hart as well. And our youngest is 8 years old. So she's in third grade. And so that's us. I went to grad school. I went to University of Pittsburgh. I got an MBA and law degree at the same time. I loved MBA school, and I also got my law degree. I'll leave it at that.
Wow.
That being said, I really, really do like what I do now. I'm in sort of an unusual area because I am basically every day talking, writing, emailing, communicating about people dying and becoming incapacitated. And if I think too hard about it, I'll just start crying if I talk to everybody. But I don't do that. I only do planning, proactive planning. I don't handle post-death matters. So I keep it very positive, very proactive. We're trying to put plans together now. We want private planning in place now, because if something happens, and it will, and you don't have planning in place, it's too late. Kind of the corollary of that is if you don't have private planning in place and something happens, it's too late, and you get the public plan, which is the court system. And when I say sort of generally, vaguely, something happening, I'm referring to universally death, someone dying, or becoming incapacitated. My clients are different. They come to me from many different ways. They are single, they're married, they have kids, they're the Brady Bunch, who don't get along. They have one property, some have none, but we'd like to see them have some. Some have many, they have a business, they have all kinds of different things and all different needs for their kids themselves. But again, universally, we want to put planning in place now, because if someone becomes incapacitated and they don't have the ability to make decisions for themselves regarding their own person, health, doctors, medicine, course of treatment, then they don't have the capacity to talk to me and put that planning in place. And the family can very easily and uncomfortably and expensively and a lot of time end up in court for conservatorship. Same thing goes with dealing with assets. We don't want to do that. We want to head that off. And if someone passes away, they, not to make light of it, but if someone dies, they cannot come talk to me and put a plan in place. And it's too late. You're in probate court for probate administration. I'm sure many of you are familiar with that in some degree, either personally or through your profession, the real estate industry. And probate itself, it's basically Latin derivation to prove out. And the court is trying to find facts and render a judgment on many, many things. Who's in charge? Who is owed what? Who may get what? What's kept? What's sold? It's just you don't want to do it. It's going to be 2+ years, even in the most simple manner, and we don't want to do it. We want to be proactive, stay ahead. You can't drive around without car insurance, smash your car into someone else, and then call your local guy to get a policy. It doesn't work that way. Same thing for what I'm doing. So that's kind of a sort of a general overview. Everything is different. I see a question up here that I just happened to glance at. can't promise I'll see everything there, but someone asked what's a general cost to put a trust together. That really varies. I can give you kind of a general price range for where I'm at typically, but it varies. For my individual clients, for my time, legal advice, consultation, drafting, getting everything together, for an individual client, and when I say individual, 95% of them are unmarried. Some portion of my clients are married and still need individual planning if they're separate property. Somewhere's low 2,000s to 3,000. For married couples, if we're doing a single combined married couple trust that only married couples can do, there's some efficiencies. We still need other separate documents. That for married couples is somewhere's between 2,500, 3,500 total. So half on a per person basis. My goal is always the mid and a bit under, but I never know what's going to be involved. So I never want to say hi. I believe in honesty and transparency. You know, if someone comes in and they say it's simple, maybe it is. A lot of people come in and say it's simple, and then it spirals out of control very, very quickly in terms of just time and hours. So it just depends. So, but I'm always flexible and happy to talk to people. Kyle, why don't you, I know you had some questions or things we wanted to discuss. If there's anything, you know, you think I should add to what I did, if anyone has a question, or Kyle, I know we were going to talk about a few things. So,
yeah, first, I really want to thank you for being here. And I want all the agents on this meeting to know that you're an excellent resource. You're local there in the Santa Clarita Valley and are happy to help with any of their clients planning their estate. It's an extra added value for an agent to have that resource for their clients, you know. So I want to thank you for being here and just make that clear. Yeah, and the other thing, you know, I want to keep our conversation sort of limited to real estate, real property in the state of California. If I were an agent on here, I would have two concerns. I would want to know what are some things that will hold up my transactions. And then the other thing is how can I help my clients stay out of court? And you had touched on that. So sort of the things I see with properties that are not held in a trust, and you had mentioned it, with individuals who hold title not in a way like joint tenancy or something that can help them avoid probate. And I've seen that probate process take an extremely long time. I was wondering if you could walk us through what the administrative process is for probate versus what are some of the benefits of holding title in a trust as far as time and effort to rectify a death or incapacitation for real property.
Sure. Yeah. Without getting too bogged down in, you know, all the legal details, a trust is going to be much more efficient, much less time, and it's going to be less costly. When someone dies, you know, their estate needs to be administered. If you have nothing in place, your estate post-death is going through probate. If you have only a will in place, your estate post-death is going through probate. If we have the assets in a trust, we can avoid probate. We want to have all the assets that can be owned by a trust in the trust. Some assets, because of legalities that I'm not going to get into here, cannot be owned by the trust. For example, on an IRA account, 401k account. But it might be really, really important to have that asset integrated with the trust. For example, my wife and I mentioned we have 3 kids. They're all under 18. Side note, in my mind, you know, before I talk to anyone 25 or under is too young to be making decisions on behalf of parents, too young to be receiving assets on their own. Your mileage may vary. You might be 21, 22 and be perfectly fine. You might be 35 or 45 and not quite financially mature yet, but you know, it's certain things to watch out for. If you have an IRA account, you know, it's not going to be owned by the trust. You don't want life insurance going directly to beneficiaries that aren't ready for it. We want to have everything integrated with the trust. Probate, you know, when someone dies, you have to do final tax returns. You have to give notifications to certain departments in the state. Assets need to be valued, and ultimately assets are in your name. They have an owner. When real estate vests, there's an owner, whether it's, you know, Fred Flintstone or Wilman Fred or whoever it is, you know, it's joint title, tenants in common, all different kind of ways. But when someone dies, now they're on title. That asset's in their probate estate. And if we haven't planned for it ahead of time, you go to court and the court's going to deal with it. That's what's happening. The court's trying to figure out who creditors are, what's going on. And it just, through probate, even in the simplest matters, it's 2+ years now. It's just, it's crazy. Things are backed up. It's not just California, it's any state. And we don't want to do that. We want to have it privately, efficiently. We want to have protections in place so assets can be held on behalf of, children. Like I said, that's not necessarily under 18. And also incapacity. If there's assets, we don't want to have to deal with probate court for conservatorship. So, yeah. Kyle, is that kind of helpful?
It does, yeah. So there were two.
I want to throw one other. Actually, Kyle, let me go back. You mentioned joint tenancy.
Yeah.
Joint tenancy, in one sense, is sort of like it can avoid probate, but it's not good for a number of reasons. It doesn't really help for any kind of incapacity. If assets are held in joint tenancy, when someone passes away, you get it. If you buy, hopefully everyone here is familiar with the concept of basis and cost basis. But very, very briefly, if anyone is not, the amount of money that you pay to acquire an asset, whether it's real estate, business, equities, stock, that's the basis in it. So if I buy a house for $300,000, that's my basis. If I sell it for $550,000, my sales price is $550,000 less the $300,000 basis. It's a $250,000 increase. So if I bought, Apple stock for that, I'm going to pay a hefty capital gains tax. If I have real estate and I'm above the exemption amount, I'm going to pay a capital gains tax. If you own an asset in joint tenancy, if you own an asset, when you die, you get a date of death valuation. So if I bought my asset for $300,000, I die, it's worth $550,000. I get, ideally, in the trust, a step up to $550,000. So if my heirs sell it for $550,000, the family's made that $250,000 profit or whatever it is, but there's no capital gains because you get a step up in the cost basis. If you own an asset in joint tenancy that you buy for $300,000, so it's $150,000 basis each, and one joint tenant dies, you only get a step up in the basis on that joint tenant. So you're leaving yourself exposed to capital gains. It's not a good idea to have joint tenancy with anyone that's not a spouse, and even then, I don't like it. I want a full step up in basis. I don't want it going to the next generation. If you're on an asset in joint tenancy, you're opening up that asset to all the other joint tenant owners' creditors. So I'm not putting my kids on it. I'm not doing anything with like that. I want it in the trust because it's there. I'm the beneficiary of the trust. I'm in control. If I'm incapacitated, someone else is in control and owns legal title to the assets in the trust, but they have a fiduciary duties of loyalty, duties of care to handle those assets on behalf of the trust beneficiary. They don't own it. It's not attachable to the trustee's creditor. So there's a lot of different reasons to not screw around and to do this properly. So yeah, joint tenancy. Yeah, if someone dies, the other person gets it, but there's a lot more to it than just that.
Absolutely. Yeah, I saw two comments in there. One was from William that said he just went through a real estate transaction where they had to go to probate and it took him 2 years, like you said.
Sorry about that, Willie. It stinks.
Yeah, it is. And then the second question, which is like, this will help us really hone in on the efficient timeline process of having a trust. So Gabby had a question. She said, is there a time frame from successor trustees to execute the living trust if the original trustees are gone? Can a successor trustee and beneficiaries hold and keep the estate of the original grantors, or do they have to distribute the estate upon the death of the grantors?
So I will do my best to synthesize those questions quickly without talking. Hopefully I get this right. Hopefully I understand the question. If for example, if Mike and Carol Brady, and they've got 6 kids, hopefully everyone knows the Brady Bunch, right? If they're not in a trust and those assets go through probate, Carol might get it all. She'll get all the community property eventually. She'll separate property. Greg, Bobby, Peter might get some, they might not. It can go to, Carol can cut them out. We want it in the trust. If they decide that they pass away, through the trust, you can leave assets to those future beneficiaries out of trust, and it just goes to those beneficiaries. So the kids can get it if they're old enough, mature enough, and it's theirs and goes on. Alternately, I think what this question is getting at, the assets can stay in trust. So if you have children or people that aren't ready yet, when you pass away, the assets don't go to them. They're in trust, continuing trust for the beneficiaries, but someone else is in charge. So for example, my wife and I have a trust. I've got 3 kids. If something happens to both of us, my brother-in-law, my sister-in-law, whoever it is going to be the trustee of those assets on behalf of my kids. And the trust can own the home, and they can live in it. If they're living someplace else, it can own the home and rent it out and keep the profits in the trust. And it can sell the home and keep the profits from the sale and invest it on behalf of the trust beneficiaries, who are my kids. So the trust needs a little bit of liquidity at that point because you're paying insurance, you're paying taxes, you're paying maintenance. The trustee hires professionals. The trustee doesn't have to go up on the roof and fix the shingles. It doesn't have to do the plumbing. It doesn't have to, know everything about finances. You hire a financial advisor, you hire a roofer, you do whatever you're going to do. The trustee is acting in absentia because I and my wife are not there. So I hope that helps answer those questions from Gabby. I don't know if you get a thumbs up or something.
Yeah,
Hopefully that helps.
yeah, and I wanted to touch to it too on just like on a title process basis. So, Gabby, if you had a listing and the two people, husband and wife, that were owners of the property have now deceased, and the children are coming to you and they want to sell the property. What he's saying is that if the property is not held in a trust, the chances are of going through probate are going to be pretty high, and that could take 2 years. If we find out the property is held in the trust, just to close the transaction, all we're going to need at that point is just original or certified original copies of the death certificates for those trustees. And escrow helps you prepare an affidavit death of trustee, or if there's an incapacitation, an affidavit change of trustee. And we move the title to that property out of those original trustees to the successors. And like you were saying, they can either continue to hold title in that manner, or now the successor trustees have the authority to sell the property. And so most of the time, within a couple of weeks after a death, in order to start planning, funeral, embalming arrangements, things like that, you have to have a copy of that death certificate. So 99% of the time, when your clients are coming to you and say, my parents, my brother, someone else has died, they're in the trust, I'm now the trustee, the timeline of ordering the necessary documents to closing that transaction is really, really fast. Most people have either copies of their trust agreement, or their estate planning attorney, like Andrew, would have copies of the trust agreement that he helped draft. And they most of the time will have that death certificate, or you can order that from the county. So I've not seen when the trust is in place, they have copies of the trust and death certificates in hand, or death certificates that need to be ordered. I've not seen that hold up the transaction. So it's just so it's just such in your client's benefit to have the property in the trust to avoid this lengthy process and holding up your transaction like we're talking about. Hopefully that answers your question, Gabby.
I saw something pop up here from Jennifer regarding special needs matters. There's different kinds of special needs trusts. I do some work, some things. If there's some things that are different, I'm happy to talk to someone, explain the difference, see if it's what I do, or if it's a very sort of subspecialty. But if someone has special needs, if they have autism or other cognitive difficulties, or they just, whatever it might be, and they're getting government benefits and they can't be in charge, yeah, you would want an asset in the trust so that someone that can handle it can handle those assets on behalf of that other beneficiary. We want to delay having that in the trust until that person needs to have it in their own name or they pass away. But yeah, just leaving an asset to some other person, that's going to blow their benefits. It's not going to be good. We want to hold up assets. I saw another thing flash by about a pension. If there's no other assets than just a pension, sort of my general-ish answer is that pensions have different beneficiaries. Their pensions have different rules. Can you name a beneficiary? Can you not? Have you retired yet? Have you not? Can you name spouse? Probably. Can you name kids? If you haven't retired yet, probably. Maybe they get a lump sum, maybe not ongoing. If you've already annuitized that pension and you're taking it out, the question would be, will the pension pay future beneficiaries, not just the spouse? Can it go to kids? Will they allow it to be in a trust? So there's sort of that world of questions going on there. Hopefully that helps that answer.
Yeah, and Lynn Fitzpatrick asked a great question, and she said, what's the most palatable way to market a trust as a way to market and start a conversation with potential clients? Well, the first thing that comes to mind for me is that, as an agent, you are assembling your team, and the increased amount of resources that you can offer to clients, like an estate planning attorney, to have a personal relationship with your title officer, to have a personal relationship with your escrow officer and your title reps, to build a team around you is invaluable as an agent to go to potential clients and say, whether it's your estate planning needs, whether it's title or escrow questions, whether it's a CPA or tax questions that you have, I have a team assembled that I can put you in direct contact with these professionals and get all of your questions answered. So having as many people on your team as possible, it will help you market yourself as an agent, I would think, for sure. But I think to talk to sellers and buyers, you repeat customers, to build that book of business, to let them know that no matter what it is for planning your estate, especially with real property, I have you handled, and I have the resources at my disposal to get you the best professional help possible.
Yeah, sort of to piggyback on that, for many people, many of my clients, that their home is the single most valuable asset that they own. The equity amounts vary, but it's substantial, and you want to protect it, right? You just don't want to leave it out there. So, there's a lot of, I'm sure you guys deal with, buyer's remorse. People are nervous. I bought my first home. It's really scary to make a 30-year commitment for a lot of money. It's very, very scary. So anything that can be done to make people feel better about it and confident for themselves, their spouse, their kids, or if they don't have children, people have, siblings they want to take care of. People have parents. There's all different kinds of stuff. But I just think that peace of mind, when I was, in my 20s and had going out at night and, pre-kids and married and just, doing my thing, peace of mind was just so much marketing bullshit. It was just, it meant nothing to me. And as I've done this for years, and I have heard from so many of my clients over the years now, this gives me peace of mind. They use that phrase. I feel better. I'm glad I've done this. I've been pushing it off. I haven't. We've thought about it. We did LegalZoom, and I'm looking at it, and I think it's garbage, and I say, yes, it is. Whatever it might be, the whole, that concept, now that I have kids, I get it, right? I'm working, a lot for the kids. My oldest is going to college, and that's expensive, and so many things in life. So it's very, very legitimate peace of mind. It's not just an insurance commercial where dad is watching his little girl grow up and they have keys to the car and they try and make you cry, right? There's legitimacy to all this. So I think, without making people feel terrible, you can use the emotions of the whole situation and positively to get things done. So, all right, hopefully that helps.
The two other last things that I wanted to touch on, and then I was hoping that we could just field some questions from people, is, will lenders lend to people in their trust? The answer to that, by my experience, is it varies. Yes. It varies from lender to lender. There's some big institutional lenders, US Bank, Bank of America, that will refuse to lend to people in their trust. And then there's like Citibank, Wells Fargo, they don't have a problem with it. So it really just depends from lender to lender, situation to situation, sometimes jurisdiction, so county to county, state to state. But I do want to say that, in title and escrow, we have a workaround for that. And we talked about this previously, Andrew, is having you, if you're holding title in your trust, like let's say in a refi process, or if someone's going to, as a buyer, wants to come into title in their trust and wants to take out a loan, you can deed out of your trust to yourselves individually. We close the transaction. The loan is in your name individually. And then the following day, we just record a deed back into the property, holding title into the trust. It keeps your title insurance policy valid. You can transfer into or out of your trust. It keeps your title insurance policy valid. And it doesn't have any overlap in your estate planning either.
Yep. I want to add something. I was going to add to that. Terry's laptop is right on top of things. Hopefully Terry's as clever as her laptop. Sorry, that was a joke, Terry. She's not smiling. Okay. So transferring your real estate into and out of your revocable trust by law is exempt from the lender calling a due on transfer clause in the mortgage, something called the Garn-St. Germain Act. So there's no worry. I'm going to guess 99% of mortgages, if you sell that property, to a bona fide buyer, they can't just take over your 2.25 mortgage. That's why they need a new mortgage, because it has to get assumed and lenders aren't going to do that. So if you transfer it to your revocable trust, by law, they cannot call that mortgage due and payable. Somewhat similarly, transfer to or from your revocable trust transfers of real estate that trigger property tax reassessment with the right paperwork, the PCOR, preliminary change of owner report, or if I'm butchering that acronym, the PCOR, you are exempt from property tax reassessment from owners transferring the property to their trust, whether it's an individual or husband and wife. You're exempt from property tax reassessment as long as you have that properly filled out and submitted PCOR. So there's no problem there.
Yeah, exactly. The PCOR, and then depending on county to county too, there are tax reassessment exemption forms. There's a number of things that qualify for the exemption. Trust is one of them. Parent to child transfer is another one of them. So absolutely, there's ways to avoid triggering that reassessment from transferring into or out of a trust, or from the trust to the successor. So thanks for answering that question as well, Andrew. One other question, if someone has an asset like a house and there's no trust in place, can an ex-wife have entitlement to that asset? I'll answer it first. I mean, it depends on if you're still married at the time you come into title of the property. Did the spouse at one time execute a spousal deed relinquishing their spousal rights to you as a married person, sole and separate? Are you acquiring the property already as an unmarried person? It would really just depend from my perspective, but I'll let Andrew answer.
I would say talk to your divorce attorney and what was the settlement and everything going on there. Yeah. If I have, and occasionally I do have a client that is divorced, but the ex is still on the property, which is kind of strange sometimes. But if you're divorced and you're going through that and you're getting divorced marriage, you should also have some kind of property separation agreement, and your assets, when you finish that process, your assets should be yours, hers should be hers, and then you move on with life. I don't do family law. I know people that are very good in family law, so I'm always happy to refer some folks. But yeah, make sure if you're coming out of a divorce, handle your assets, get them in your name, because you don't want to inadvertently leave your ex as the beneficiary of insurance, 401k. You don't want them on stock certificates for your company that you own. You don't want them on your house if you're moving on with life. Get it done.
Yeah, absolutely. And then, so one other comment, and it's great from Renee, reminder, after you refi and remove your property from the trust, make sure to put it back. I would tell you that all the good escrows that I work with will prepare 2 grant deeds to go along with that deed of trust when I'm sent. We record the grant deed coming out of the trust and the deed of trust concurrently. And then the following day, we already have in hand the grant deed going back into the trust, which we record on a quote unquote, it's called the delayed basis. So we have both of those deeds in hand when we're doing transactions like that.
Is that, Kyle, you're talking about for a refi?
Yes, exactly.
That's
so
awesome.
If a lender won't lend to you in your trust, you're going to execute a deed from yourself out of the trust, which you don't have to pay transfer tax on. It qualifies for that R&T exemption. Right. You record the deed of trust. So now, and if it's owner occupied, you don't even pay SB2 fees, which is great. And then, like I said, every good escrow will prepare the second deed going back into the trust that a title company will record on a delayed basis. So
right. And I will say, just this kind of spurring this now, if you guys do that, that's fantastic. And that's awesome that you guys do that, because many title companies do not do that. And, you know, if my clients are my clients and they buy something else and they're talking to me about the upcoming transaction process and the lender doesn't put it back in, they need to come to me and then I need to do it and put it back. So if you guys do that, part of that process, that's awesome.
Yes.
That's great.
Perfect. Looks like there was one other question too from Renee. It says, once someone passes away, how long does it take for you as the trust attorney, Andrew, to be notified so that you can notify the family and trustees?
Well, let me kind of answer this sort of kind of semi-quickly, a couple different parts here. My practice has grown. I don't really handle much in the way of post-death matters. I stay out of court. I do planning, and I like it that way. I know a couple people that are really, really good in the post-death world, and they don't do any planning, and I work really well with them, and I'm happy to talk to anyone that has some questions. I can, you know, do some hand-holding, make a referral, and kind of help with that situation. If someone passes away, if I'm answering the question quite literally, someone passes away, there's no automatic trigger that I'm notified. It's someone's got to, let me or whatever the attorney know that someone's passed away. But then there is the process, and what's involved. It just depends on what the estate is, right? Is it one person with one home and one child? Is it the Brady Bunch? Is it the Brady Bunch that now is not getting along? Is there a business? Is there multiple properties? Is there, an alcoholic son? Does the daughter have is the son-in-law someone they can't stand and assets need to go in trust? There's, you never know. Kind of all these things are potentially on the table and in the picture.
Yeah. In the title world, if someone passes away and they're the trustee of the trust, I would say typically the next person to act as successor trustee is aware of the death. They usually have a copy of the trust. They usually can obtain a copy of that death certificate. They're typically familiar with who if there's a co-successor trustee, or who the beneficiaries are. Do they have access to those trust bank accounts for that when they sell, the proceeds can be distributed to the trust? Most of the time, these people have all of this in order by the time we see it title and your orders open. So all we need is just a copy of the trust. We need to know that successor trustee named in that trust is the one that's acting on behalf of it, and get a copy of the death cert. So it really doesn't take that long as far as closing the real estate transaction, notifying other heirs, divorcees, beneficiaries down the road with the proceeds. That's sort of something we stay out of, at least in title.
Yeah, and it just depends. I mean, I tell all my clients, once we do this and you finish, make sure that the people, so if you're single or you're married, and something happens and you're incapacitated, you pass away, and other people are going to step up into roles to be handling things, make sure those people are willing to do it. Don't just, you don't want to surprise anyone 25 years down the road. Make sure those people are willing to do it, and then keep those original documents in a safe place, but make sure that the people that are going to be stepping into your shoes during incapacity, after someone passes away, make sure they know these documents exist, they know where they are, and they can access them. The original documents are most important. Clients keep the original documents. I like to get a scanned copy of the signed one when possible, just as an extra backup. My own E&O insurance tells me I am not a document storage warehouse, and I should not be telling clients I'm going to keep the original documents. I don't do that. Shoot, the county recorder doesn't even keep the original signed deeds anymore. They do whatever they do to record them and send the original wet signature documents back to the owner. They don't even want them. So keep your original documents.
Yeah.
Whether it's a contract, whether it's your closing, whether it's signing up with a financial advisor, keep your documents. Be organized. Be responsible.
Yeah. Just quickly, I don't want to interrupt. This is such great dialogue, and I mean, I'm learning so much. I hope you all are as well. There's 4 questions that have been unanswered. So I'm going to throw it out there. And if we want to add, we're going to stop questions after those 4, just because we really, truly want this to be, Workshop Wednesday, respect your time within 30 minutes. We're a little over, but this is such good information. Let's answer these last 4 questions from Gabby.
I thought we were an hour here, so that's cool. So I do a few minutes. So.
If everyone, anyone can sign off that doesn't want to be on, but if you're learning, please stay on. So let's answer these ones. And then
where are we going back to, Madison, on here? Because I can scroll a little bit.
So the Gabby, Susie, Anna, and Renee. And then
Hegstead. All right, let me see if I can knock these out real quick.
Thanks so much.
Hegstead case. It says, is that the Hegstead case? I'm not sure what that's referring to above, but if we want all assets in the trust, if an asset is not in the trust and someone dies, it's in your probate estate. If it's not in your trust estate. So there is something called a Hegstead petition, and it's named after a family. That's the word itself means nothing. It's just named after a family decades ago. So you can file a Hegstead petition with the court as long as you have a pour over will along with your trust, and you should always do that. You can file a petition with the court to get the asset, whether it's real estate or whatever it is, quote unquote, poured over into the trust. But that's a backup. Don't count on that, because you're petitioning the court to get the asset taken out of the probate estate and put into the trust. So is it full-blown probate administration? Hopefully not. Are you in court? Do you have appearances? Do you have stuff? Wasted time, wasted money? Yes. But the Hegstead, if there's an asset that for some reason you don't know about, or someone drafts a trust and then drops dead and hasn't recorded the deed, or you inherit a cabin in Wyoming from your Uncle Frank and you don't know about it, yeah, there's ways to get it into the trust later, but it's a backup. It's just a backup. Most of the lenders I work with will allow for, yes, some lenders do. It's changed over in my experience over the years. Many lenders did not underwrite the home in the revocable trust. Some do now, much more than even a few years ago. Not all of them will underwrite the asset in a trust. It's, if you can get them to underwrite the loan, the mortgage, and close escrow on a new home in the trust or refinance in the trust, that's great. And that's great. If they'll do that, make sure if they're willing to do that, that it's the same rates, points, fees, everything as if it was not in the trust. Because some lenders, you know, if you have an irrevocable trust, if you're the Getty Center and that's held in the Getty Trust and you have billions of assets, they might want a loan on some of that property to take some money out, do whatever they want to do with it. If they're acquiring something, they might not pay cash, but they're not taking assets out of the trust to put it in Lord knows whose name, right? Some drug addicted great grandson of J. Paul Getty, to put the asset in that guy's name to underwrite the loan and then try and wrest it out of his, you know, hands to put it back in the trust. So lenders do underwrite loans in the trust. And many do now in irrevocable trust, which is the overwhelming majority of my clients. But make sure if you are underwriting in the trust that you're getting the same loan, the same terms as if it was out of the trust. I'm looking to next one here. I think it's cut off.
Anna.
Here. Anna, for the benefit. I'm not sure I'm understanding the question. The property is an asset. So if you inherit a property and you sell it, well, the PCR is dealing with property tax. There's different kind of tax. Where there's income tax, there's property tax, that we have, you know, sales tax, and there's capital gain tax. That's part of income tax. So the PCOR is really dealing with, you know, any increases in property tax. Selling a property is capital gain tax. So they're different things. If someone dies, you get a date of death valuation on that property. So if the property is initially acquired for $300,000 and they die and the date of death valuation is $550, and now it's in an ongoing trust and it's sold later for $700, the tax will be $700 minus the $550 stepped up basis for a tax on that $150, but not the difference between the $700 and then the $300. So not $400,000 gain, but just $150. And I know I'm talking quick, and I hope it makes
we appreciate this. And keep in mind, everyone, I did put Andrew's contact information to his direct office. So any questions that didn't get answered or maybe need more explaining, the contact information is there. I don't want to go too far over our time. And so I'm just so thankful that everyone was able to make it today. I hope this doesn't sound condescending, but I'm so proud of everyone for coming, because I think it's so amazing that you guys want to expand your knowledge for your clients. I mean, I just think it's so great. This is not something that you can plan for it because you can contact Andrew, but you know, you don't know when something like this is going to happen. You don't know when you're going to deal with a transaction like this. So I'm just happy that you guys were all able to join and learn with us. We will absolutely, if you want the recording of this, please reach out to whoever your title rep is at Consumers Title, and we will get that recording to you through a link. I know Star says we need more time. Jennifer says 30 minutes is too short. We want to just make sure that everyone can attend, you know, so we keep it to 30 minutes, but genuinely grateful. Kyle, Andrew, you're wonderful. You have just a wealth of knowledge. I'm so appreciative. Did you guys want to sign off with anything?
I just want to thank Gene, Madison, Kyle for inviting me today, letting me be part of this. If folks have some questions, happy to chat for a few minutes, and you know, if it's something that I can do, terrific. If it's not something that I can do, you know, I know attorneys in other areas tangentially related. I'd like to be a resource when possible. I'm around.
It's so great to connect.
And if I don't answer, leave a message. I like to call back messages. I get so much garbage, junk phone calls, but just leave a message for me.
Don't we all? And I guess last thing I will let you know, our next workshop Wednesday, mark your calendars, June 22nd. It's a Wednesday. We're back to our 10 a.m. time. If you guys know agents that would like to come to these, feel free to reach out to us. The more the merrier. Our topic will be a little bit more exclusive to Santa Clarita Antelope Valley territory, full disclosure, because it will be talking about the Mello-Roos in that area, track maps. But we'll also be sharing some other things on our website, like video tutorials for all of our title tools and that type of stuff. So if you have any questions, please reach out to any one of us. Thank you all for coming today. I wish we could stay and chat all day.
Mm-hmm. Thanks you guys so much.
Bye guys. Thank you so
Thanks,
much.
guys. This was amazing.
Have a wonderful Wednesday. Maybe we'll have Andrew back if he'll join us.
Yes, please.
Maybe
Hi,
we'll
Andrew.
do a special 1 hour.
Madison, can you repeat that date for the
I
next
saw
one,
your
please?
message. Yes, June 22nd is the next workshop Wednesday.
10 a.m.
Always
10 a.m.
reach out to us if you forget. Another easy way to remember is it's always the 4th Wednesday of the month. So yeah, so great to see you all. I hope you have a wonderful day. Thanks, Kyle. Thanks, Andrew.
Thank you guys.
You're welcome.
All of our consumers title people.
Thank you guys so much. We really appreciate it.
Hi, Star. Everyone wants Andrew back.
Billy,
Yeah.
cut the
Get him
Zoom.
back. Get him back. Too short.
Bye, guys.
Bye. Stop recording now. Bye.
Billy.
Holly, nice to